Hello, and thank you for joining me for the Secrest Wardle Premises Liability webinar series on notice in premises liability actions. This series is part of our overall discussion of premises liability case law in the state of Michigan and updates in the law since our last series launched in 2016. So today I'll go over some basic information about notice in Michigan. Then I'll go through the case law, especially the leading published cases that have come down since 2016. As many of you know, notice in Michigan is a requisite element of a premises liability action. Michigan follows the restatement of torts, and a person must first establish a duty owed in a premises case before they have a cause of action. A duty in a premises case rests on two sections of the restatement of torts. First, the section 343 states that a possessor of land is subject to liability for physical harm caused to his or her invitees by a condition on the land if, but only if, he or she knows or by the exercise of reasonable care would discover the condition and should realize that it involves an unreasonable risk of harm to such invitees and should expect they will not discover or realize the danger or will fail to protect themselves against it and fails to exercise reasonable care to protect themselves against the danger. Second, the Restatement of Torts, Section 343A1, provides that a possessor of land is not liable to his invitees for physical harm caused to them by any activity or condition whose danger is known or obvious to them, unless the possessor should anticipate the harm despite such knowledge or obviousness. So, as you know, in a premises action, the status of a person on the premises triggers the level of duty of care owed. In premises liability actions, an individual is either going to be an invitee, a licensee, or a trespasser. And the long and short of it is that an invitee is someone that has some sort of business relationship with the premises owner. For example, guests at restaurants or apartment complex. These people are given the highest level of duty under the law. Now, social guests are considered licensees, and it lessens the duty when you're at, like, for example, a friend's house or just visiting someone on their premises. If you're not conferring any kind of economic benefit, then you would probably fall into the licensee category. And finally, there are trespassers in which the person is not an invitee or a licensee and is not supposed to be on the land. We'll go over some formal definitions here. An invitee includes guests at a restaurant, businesses, apartment complex, etc. A public invitee is a person who is invited to enter or remain on land as a member of the public for a purpose for which the land is held open to the public. A business visitor is a person who is invited to enter or remain on land for a purpose directly or indirectly connected with business dealings with the possessor on the land. Defendants or premises owners have a legal duty of reasonable care to protect invitees from unreasonable risks of harm caused by a dangerous condition they know or should have known the invitee would not discover, realize, or protect themselves against. A business invitor, which is the person who owns the land or the property possessor, has three duties to an invitee. There's the duty to inspect, the duty to warn, and the duty to protect and make safe. So if you're a premises possessor, you are charged with inspecting your premises to ensure the safety of your visitors. You're also charged with warning your visitors of any, for example, like wet spots on the ground or any icy conditions on the premises, and it's your duty to protect or make them safe. So if you have a giant hole in the ground of your parking lot, it's your duty to ensure that you are making that area safe by putting up a barricade or signs or something to alert your invitees to that hazardous condition on the premises. Now, a licensee is a lessened legal duty of care. And typically that includes social guests. So if you have family or friends over to your house, they would be considered licensees under the law. And that changes the duty of care owed to them. Defendant landowners have a legal duty to warn licensees of dangerous conditions on the land, which the owners know or has reason to know if the licensee does not know or have reason to know of the condition. A landowner does not owe a licensee a duty to inspect the premises or to make the premises safe for the licensee. A landowner only owes a duty to warn social guests or licensees. Now, there is very little duty to trespassers, and in fact, generally, landowners do not have a duty to trespassers to notify them of any condition on the land. However, landowners cannot actively injure trespassers in an effort to keep them off their property. So, for example, you can't have bear traps or covered pits on your property to keep trespassers out. That will typically be found to be in violation of the duty owed, but generally there is no duty to trespassers to notify them of any condition on the land. However, there is the exception for child trespassers. There is a duty for child trespassers if the condition may be considered an attractive nuisance. A possessor of land is subject to liability for physical harm to a child trespasser caused by an artificial condition on the land, and there are several elements that invoke this type of duty. So again, there is a duty to landowners for child trespassers if the condition may be considered an attractive nuisance. And liability may exist for an artificial condition on the land if the place where the condition exists is one upon which the possessor knows or has reason to know that the children are likely to trespass, or that the condition is one in which the possessor knows or has reason to know, and which he realizes or should realize will involve an unreasonable risk of death or serious bodily injury to children. In addition, liability may exist if the children, because of their youth, do not discover the condition or realize the risk involved in meddling with it, or the utility to the possessor of maintaining the condition and the burden of eliminating the danger are outweighed by the risk to the children involved. And finally, if the possessor fails to exercise reasonable care to eliminate the danger or to protect the children. Now, typically in premises liability actions, you're going to find that the plaintiff will be classifying themselves as an invitee. It's not often that you get the licensee kind of case, just because the duty owed there is much, much smaller. Now, you'll see a lot with premises liability actions against businesses, grocery stores, or just any kind of business that has a parking lot in which there's snow and ice issues, or there's asphalt issues, or there's some sort of pothole that, causes some sort of risk of harm. So some common examples of defendant's duties as a business invitee in these types of situations are clearly outlined in a lot of bodies of case law. Now, with regard to items on floors, aisles, and conditions in a store, it's the duty of a storekeeper to provide reasonably safe aisles for customers, and he is liable for injury resulting from an unsafe condition either caused by the act of negligence of himself or employees, or if otherwise caused, wherein known to a storekeeper or has existed a sufficient length of time if he should have knowledge of it. Oftentimes the debate here is what is a sufficient length of time. And we've won cases where, just a couple minutes have passed in between the time that the water was on the ground, or the grape was on the ground and someone had slipped and fallen on it. You have to do your due diligence in the initial investigation of these cases, pull the surveillance videos, see if you can time how long this alleged hazardous condition was actually on the ground. And the plaintiff will rely on this Sorrento versus Borman Food Stores case and the body of case law that comes after that. Another common example of defendant's duties to business invitees is in snow and ice removal cases. Generally, a business invitor is required to take reasonable measures within a reasonable amount of time of the accumulation of ice and snow to diminish the hazard of injury to an invitee. In the case of Derbabian versus Mariners, the plaintiff failed to establish constructive notice of icy conditions where it had not snowed for several days. It had only rained for a few hours before reverting to freezing temperatures. The ice patch was only the size of 2 parking spaces, and no other person, including the plaintiff, had observed the ice before the fall. So that right there would fail to establish notice on part of the association or the defendant in that case. So if you are representing or you are part of a company that has these kinds of claims, or you're the business owner and they say that they slipped and fell, I anticipate and I would hope that your counsel will be looking to see the weather records for that day to see if it had snowed. You could also see if your snow plow company had kept logs of the weather for that month, if they indicated that there were a certain amount of inches of snow on the ground or not. All of those facts are going to help you defeat the notice element in a case and to allow you to argue that you did not have any notice of the alleged hazardous condition and therefore you're not liable for the injuries. Now, another common example of defendant's duties is the McDonald versus PKT case, which involves the criminal acts of third parties. And in that case, the Supreme Court established that merchants have no obligation to anticipate the criminal acts of third parties and are not obligated to do anything more than reasonably expedite the involvement of police once criminal activity becomes apparent. So in these kinds of cases, you don't have a duty to expect that a robber is going to hold up a grocery store. What you do have a duty to do is to call the police or to make sure that, if you're able to get authorities involved, that you do it promptly or once the criminal activity becomes apparent. But you cannot expect that, there's going to be a gunman entering the store, and you cannot be held responsible for those criminal acts of the gunman or any third party that is engaging in a criminal act. Now, there are key issues to focus on when you are looking at these kinds of claims. You look to see what condition is involved. Did the store owner or the store employees cause the condition or contribute to it in some way? Did the store owner or employees know of the condition? When did the condition form? How long was it there for? Is there a way to track it or to see the time? Is there surveillance of videos showing how long it was there for? Are there logs anywhere that exist? Are there any store employees that knew of the condition or should have known of the condition? You also want to focus on the frequency of the condition on the premises, including in that location. So let's say, you have an ice delivery company that delivers ice to your store. Do they come through the back way and drip water all down the aisles? Has that happened before? Have people, alerted you to this hazard? Those are all the facts that are either going to be helpful to you or not in the defense of a case. And you also want to see who or what caused the condition to form. Is it someone else on the premises where you could be out on SD for an open and obvious issue, but they might still pull in the ice company or the chips delivery guy to your store, whoever is engaging in these activities for a general negligence claim. Now, you also want to focus on when the property or premises owner became aware of the condition. That's going to be a big focus in any kind of deposition or any litigation that takes place, is who knew this information, when did they know the information, and for how long did they know this information. And if you can get ahead of the game and get all of that information before opposing counsel does, or even before it gets into litigation, then you should be in good shape for the defense of the claim going forward. Or, you might be able to step back before it even gets to litigation and recognize what the issues and weaknesses are going to be in a case. Now, again, document everything. Photograph the area if possible. Assess when the condition came to be, when the condition began, when did it end, did somebody clean it up, who cleaned it up. Talk to the people that were in that vicinity as to what they saw and how long they saw it. Get them to issue witness statements, obtain their names and addresses if available. Make sure that you have a method of reporting in place. So, you want to have some sort of incident report form that documents, the incident, and you can have customers or employees weigh in on this, but you want to have a very clean record, an important way of documenting how these conditions began and occurred, because those are going to be the key documents that are presented in the litigation process and at trial. Now, that's just an overview of the notice requirements and the notice element in Michigan, and you can have a full read as to the notice requirement in our premises liability handbook. That will provide you with the overview, the case law, and more of a detailed explanation about notice in Michigan. So we'll talk a bit about some case law that came down since 2016, which is when our last series launched. The largest case to discuss is the Lowry versus LMPJ case, which is a published decision by the Michigan Supreme Court. In Lowry, the plaintiff was a restaurant patron who slipped and fell while descending down wet stairs. She filed a premises liability action against the operator of the restaurant, which moved for summary disposition. The trial court granted defendant's motion, but the Court of Appeals overturned the decision, ultimately holding that defendant failed to present evidence that it lacked notice of the hazardous condition. Reversing the appellate court, the Michigan Supreme Court held that defendant was entitled to summary disposition as the premises possessor did not have to present evidence that it lacked notice of a hazardous condition that allegedly caused the invitee to fall. Defendant only needed to show that the invitee plaintiff presented insufficient proof to establish the notice element of her premises liability claim. The Michigan Supreme Court made clear that the premises owner does not have the additional burden of producing evidence to disprove the plaintiff's claims. Now, the rule of law that comes out of the Lowry case, which is a Supreme Court published decision, is that defendants only need to show that an invitee plaintiff presented insufficient proof to establish the notice element of a premises claim to obtain summary disposition. The Michigan Supreme Court made clear that the premises owner does not have the additional burden to produce evidence disproving the plaintiff's claims. They just need to say that this is the plaintiff's burden of proof, here's what they have to prove, and Your Honor, they have not met that burden of proof, therefore the case should be dismissed. This is important because a lot of times the plaintiffs will try to shift the burden of proof onto the defendant and say, prove that you didn't do anything wrong. And I think, you have to have strong defense counsel to turn around and say, I don't have to prove anything. I don't have the additional burden of producing evidence to disprove your claims. You have the burden of proving your claim to me and to the court. And this is a good case to rely on, especially in motions for summary disposition when the plaintiff is trying to shift the burden in the case and is truly just relying on their claims, relying on what their allegations are, but don't have any true evidence to establish their claims once they get past the point of filing and after discovery closes. Now, there are a few more cases that came out. These are unpublished cases, so they're not binding, but you can use the unpublished case law as persuasive authority if you're in litigation to say, hey, Your Honor, this case is analogous to the one at hand. This is how the Court of Appeals has decided the issue, and we ask that you look at this in the same view. So we'll go through these cases. They can be applicable to your claims handling as well if the facts match or are applicable in some way. Now, the Priester versus Bell case was a Court of Appeals opinion issued in August 2016. In that case, plaintiff fell because of a loose front porch step at a home she leased from the defendant. She sued defendant alleging breach of duties owed under common law and MCL 554.139. Defendant filed a motion for summary disposition, arguing that she had no notice of the alleged hazardous condition and in fact had inspected the steps on 2 occasions before plaintiff's fall, and they appeared to be in good condition. The trial court granted defendant's motion, holding that defendant did not have notice of the alleged hazardous condition and made reasonable inspection of the premises. On appeal, plaintiff contended that a jury could infer from the defective step was improperly affixed to the front porch, thereby creating a genuine issue of material fact. The appellate court disagreed and upheld the trial court's grant of defendant's motion for summary disposition. In the Lloyd versus Westbourne Fruit Market case, the defendant appealed an order denying its motion for summary disposition. The plaintiff filed suit alleging she slipped and fell in the parking lot at defendant's Westbourne Market. According to the plaintiff, she slipped on a flattened white wax cup. Plaintiff maintained that the white cup was lying on a white parking space line and that in the evening hours, the white cup blended in, making it invisible. Defendant filed a motion for summary disposition and argued that there was no evidence that defendant had actual or constructive notice of the alleged cup. The trial court denied defendant's dispositive motion, but the appellate court reversed and remanded for entry of summary disposition in favor of defendant. In essence, the appellate court noted that plaintiff's own deposition established that the cup would have been visible to ordinary user upon casual inspection. As the cup constituted an open and obvious danger, defendant had no duty to protect or warn plaintiff of the hazard. Further, there was no evidence that defendant had notice of the alleged hazardous condition. In Bacon v. Sunshine Products of Michigan, that is a 2017 case, the plaintiff visited defendant's premises, which was a landscaping company. As he attempted to leave, he slipped on the store's wooden deck and was injured. He testified that after he slipped, he touched the deck and felt that it was slimy in the area in which he fell. He described the substance as almost invisible and said that he could not see it but only could feel it. The substance did not leave a residue on his hand and seemed to be part of the wood. Defendant moved for summary disposition, asserting that it had no notice that the deck was in a defective condition. The trial court granted summary disposition on the basis that nothing indicated the substance or condition was caused by defendant, or that it was there for a sufficient amount of time that defendant would be charged with knowing or should have known of the alleged condition. And again, this goes back to the elements that we were discussing earlier as to the knowledge requirement and the length of time of knowing that a substance had been there. In addition, the court looked more to the plaintiff's lack of proofs in granting summary disposition, which goes back to that Lowry case we discussed. In Fagan versus Usnes and Family United, plaintiff drove his car to defendant's clubhouse to pay his apartment rent. He initially walked on the sidewalk without incident, but as he walked back toward his car, he slipped on a patch of ice on the sidewalk, sustaining very serious injuries. The plaintiff filed suit against defendant alleging negligence and violation of its statutory duties as a landlord. Plaintiff testified that he was unaware of how long the ice had been on the ground and presented no evidence indicating the length of time the patch of ice had been present. Defendant moved for summary disposition, contending that it had no knowledge of the ice and that the condition was open and obvious. The trial court agreed. The Court of Appeals affirmed the decision of the trial court. In Lloyd versus Apple Venture, plaintiff was a business invitee on defendant's Applebee's restaurant. Plaintiff walked to the restroom, and on her way back, she slipped and fell on an area of tiled flooring in the front of the kitchen. After her fall, plaintiff noticed an oily residue on her hands and knees. Plaintiff contended that defendant knew or should have known or been aware of the condition of the floor and failed to properly maintain the premises. The trial court granted summary disposition in favor of defendant upon concluding that plaintiff failed to establish a genuine question of fact whether defendant had noticed or created the dangerous condition. On appeal, the appellate court noted that plaintiff must present evidence that the hazard existed for a sufficient period of time and that a reasonable premises owner would have discovered the alleged danger. Plaintiff failed to meet this burden. Accordingly, the appellate court found it speculative to deduce that defendant was responsible for placing grease on the floor or should have been on any notice of grease on the floor. Got two more cases for you in 2017 and 2018. That's the Cadra case and the Letourneau case. In Codra, the plaintiff left his apartment building, which was owned by defendant, to go to work. When plaintiff stepped on a concrete sidewalk outside of his apartment, he slipped and fell on ice. Plaintiff brought an action against defendant alleging premises liability violation and a violation of the statutory duties under 554139. Defendant moved for summary disposition, contending that the ice on the sidewalk was open and obvious with no special aspects and the sidewalk was fit for its intended use. In a written opinion and order, the trial court found the ice on defendant's premises was open and obvious with no special aspects, and that although the sidewalk was not fit for its intended use under the relevant statute, there was no evidence that defendant had actual or constructive notice of the condition. The appellate court agreed with the findings of the trial court and affirmed summary disposition. Now, the final case we have to talk about today is Letourneau versus Edison. In that case, plaintiff attended holiday nights at Greenfield Village, which is a very spectacular scene if you haven't gone. As she approached the holiday display, she tripped and fell on a curb, fracturing her knee. She filed a premises liability action contending that the darkness and crowd of people obscured her ability to see the curb. Defendant filed a motion for summary disposition on the basis that the curb was open and obvious. Plaintiff responded by arguing that the curb was difficult to see due to darkness and the crowd. Ultimately, the trial court granted summary disposition and held the curb presented an open and obvious condition despite the darkness. Further, there was no special aspect creating an exception to the open and obvious danger doctrine. The Court of Appeals affirmed the decision of the trial court and further stated that a central element of every negligence claim is negligence, that a defendant breached a standard of care. Here, there was no evidence of negligence committed by a defendant in its care or maintenance of the premises. Further, there was no notice on part of defendant indicating that the curb or holiday display presented a hazardous condition. Now, those are all the updated cases in Michigan since 2016. If you would like, a more comprehensive overview of all the case law outlined in our handbook, feel free to contact me or our marketing department through Linda Williamson to get a copy of our Premises Liability Practice Group handbook. Thank you for attending the Notice Knowing What Was Wrong webinar. Please contact me with any questions or comments you may have. My contact information is in this last slide. Thank you.